Welcome to our House Committee hearing for the Judiciary and Hawaiian Affairs Committee. Today is Wednesday, February 7th. It's 2 p.m. here in Conference Room 325 at the State Capitol. Our hearing is also by video conference as well. Thank you very much, all of you, for being here. Appreciate your testimony and your presence today. For those who are testifying, I'd like to ask if you could limit your testimony to 2 minutes. I'll ask you to wrap it up at that point. And if you're testifying over Zoom, just keep yourself muted and your video off until I call on you to testify, and then again mute yourself and turn your video off after your testimony is complete. If you have technical issues, use the chat function to contact technical staff. If you're disconnected unexpectedly, don't panic, just try to get back on, and I'll try to fit you in as soon as you rejoin us to make sure we hear your testimony. In case the power goes off here and we have a whole system failure, we'll reschedule the hearing and we'll post notice so you'll know. If you're testifying on Zoom, please don't use any copyrighted or trademarked images. That kicks us off of YouTube, and that's a problem. So, and if you would all please conduct yourself with aloha, no profanity or uncivil behavior. As you know, I believe it's okay to disagree, but let's not be disagreeable. We're here, all of us, to do the best for the state of Hawaii. So let's work as allies to that end. Okay, first up, we are going to hear House Bill 1610, relating to public records. This measure imposes a cap on costs charged to reproduce certain government records, waives reproduction costs charged for the first 100 pages if disclosure serves the public interest, waives costs charged to duplicate certain government records in an electronic format, and imposes a cap on costs charged to search for, review, and segregate records. It also provides a waiver of fees when a record's disclosure serves the public interest. First up, we have testimony from the Attorney General. Welcome. Why don't you use the podium and the microphone so everyone can see you in TV land.
Good afternoon, Chair, Vice Chair, members of the committee. I'm Stella Kam, Deputy Attorney General. The Department of the Attorney General opposes this bill for various reasons, including the fee cap. We note that our department uses deputy attorney generals to do the search, review, and segregation. As a result, we do have significant UIPA requests sometimes, which does take. If I may ask you not to use acronyms, could you just explain when you refer to an acronym that would help me, who's not a lawyer, and everyone else who's watching? Okay. The Uniform Information Practices Act allows members of the public and others to make records requests to government agencies. And our department, when we do receive those requests, deputy attorneys general are assigned to do the searching, the reviewing, and the segregation of confidential information from those records. So the fees that this bill contemplates are extremely low and would not in any way cover our costs. We believe that our department, as well as other agencies, might have to request funds for additional personnel to handle these types of requests. We also have concerns about the public interest waiver. We believe that, as written, the public interest waiver could be claimed by any of the requesters of records, and it would essentially make it free, completely free for them. Thank you. And I'm available for questions if you Thank you very much. I appreciate that, Deputy Attorney General Kam. Next, we have comments from the Department of Corrections and Rehabilitation. Please come on up and introduce yourself and give us the highlights of your testimony, please.
Good afternoon, Chair, Vice Chair, and members of the committee. My name is Melanie Martin. I am the Deputy Director for Administration, testifying on behalf of Director Tommy Johnson. We stand on our written testimony, offering comments. Thank you.
If I could ask you to highlight your comments, please.
Just as the Deputy Attorney General said, we oppose the cap, as well as we don't believe that we should be reproducing copies because anybody can claim a public interest. So we shouldn't be actually having to reproduce copies, reproduce and do the research and the reviewing and it takes a lot of staff time, and more staff would be needed, and overtime costs would be incurred as well. Thank you.
Thank you very much. Appreciate that, Deputy Director. Next, we have testimony from the Department of Accounting and General Services. Welcome. It's Dr. Archives.
It is. Good afternoon, Chair, Vice Chair, members of the committee. On behalf of Comptroller Regan, I am Dr. Adam Jansen, and it is my privilege to serve as State Archivist. DAG stands on its testimony, which states that
DAGS is the
Department of Accounting and General Services stands on its written testimony. You're going to be harder pressed to find a bigger advocate for public records in the archives. But with that being said, we are 14,000 cubic feet of nothing but public interest. That is why those records going back to 1790 are in the archives, because they protect public rights. A simple request such as dealing with a fish pond, having to dig up every record back to 1790 dealing with a fish pond will absolutely devastate my agency. We are already overwhelmed with public disclosure requests from the normal fee schedule. You start waiving that, we will not be able to operate. And so I thank you for the time. If you have any questions, I'd be happy to address them.
Always a delight to see you,
Thank
sir. Thank you. Next, we have testimony in opposition from the Department of Land and Natural Resources. Welcome. Please introduce yourself. Please proceed.
Thank you. Good afternoon, Chair, Vice Chair, members of the committee. My name is Ben Lee. I appear on behalf of Don Chen, Chairperson of DLNR. So DLNR stands on its testimony, written testimony in opposition. I can only add that, in our experience, many of the requests from the public can be labeled as dubious, as claimed as public interest. So we believe that a waiver, blanket waiver is not a good idea, and I think the divisions, the departments should be given the opportunity to decide if they would grant a waiver or to give a discount in a specific request. So we're dealing with a lot of record requests, and I can tell you many more than fish ponds. We deal with telescope cases. We're dealing with beachfront properties and all sort of things, boating issues, and we have a lot of very broad requests that could take our time, to compile the record and to reproduce the record. So we would like to see that the departments would be given the chance to make the decision instead of making a blanket waiver. Thank you.
Thank you very much. Next, we have testimony with comments from Cheryl Park, Office of Information Practices. Welcome. Good to see you again, Director. Please proceed.
Office of Information Practices, or OIP, provided extensive written testimony with facts, statistics, and explanations, which I am going to try to shorten into 10 bullet points. And sorry that it's emphasized, in bold and stuff in my testimony. It's just that it was so long. So I wanted to kind of highlight the important things in that for you. But I want to start with the bottom line that these proposals are a solution to a problem that doesn't exist and will end up creating more new problems. The objective evidence collected by the UIP record request logs since 2015 shows that the overwhelming majority of requesters pay no fees or costs.
And the UIP is?
As she explained earlier, the Uniform Information Practices Act, or Hawaii's Open Records Law.
Humor me just by repeating it as well. Thank you.
So over 90% of state requesters and over 86% of county requesters pay absolutely zero. For the more complicated requests, the majority who pay are the private sector attorneys, businesses, special interest groups, and other entities. OIP already protects against excessively high fees that are not justified. You can see OIP opinion number 23-02. Currently, UIPA record requesters are receiving the records much faster and usually under 9 business days, compared to requests that are made under the Federal Freedom of Information Act, or FOIA, which typically take hundreds of days, if not years, to resolve. By incorporating portions of FOIA's more complex fee structure and waiver provisions that are inconsistent with the UIPA's simpler structure, this bill would increase agencies' costs and response times for all record requests. Besides changing the standard for the public interest waiver, the bill would make it a complete waiver of all fees, no matter how large the request will be. And I'm on number 6. The bill's proposed caps of $5 and $7.50 would not allow the rates to be raised enough to reflect the average salaries from 7 years ago in 2017, or the collective bargaining and inflationary increases since then. The statutory fee cap also operates as an unfunded state mandate that must be paid out of counties' coffers. 7, without the ability to charge reasonable fees, vexatious and complex record requests will increase and interfere with agencies' ability to do their primary functions or to timely respond to all other UIPA requests without substantial ongoing increases in state and county personnel and funding. 8, although Hawaii taxpayers fund agencies' work at the state level and county, the UIPA does not distinguish between fees and costs charged to residents versus non-residents, or between nonprofit or for-profit entities. Number 9, ironically, the proposed new public interest fee waiver standard would create a new distinction that would likely exclude requesters from for-profit media organizations like the Star Advertiser, while nonprofit media organizations like Civil Beat would benefit from the proposed new standard. And finally, number 10, if this bill passes, we ask that it provide for a 2 to 3 year delayed effective date so that OIP can make the necessary changes to these rules. So I'm available for any questions.
Thank you very much. Good to see you again. Next, we have written testimony with comments from the Employees Retirement System, Department of Budget and Finance, Department of Education, University of Hawaii, testimony with comments from the Honolulu Police Department. Please proceed online. Please proceed.
Hi, good afternoon, Chair, Vice Chair. I am Carlene Lau, Acting Major of the Honolulu Police Department's Records and Identification Division. We submitted written testimony. We stand on our written testimony. Just to summarize, we have the same comments and concerns as the previous agencies and departments that have testified today. Part of it is that a waiver of the fees would increase the number of requests from public interest groups, and it would overwhelm our system. The second thing is that the existing fees are already extremely, they don't even cover the cost of the duplication of records at this time. So we feel that the fee schedule is appropriate, and it's barely keeping up with the cost of staffing and reproduction as it is.
Thank you very much, Major. Any other comments?
No, I'm available for questions.
Okay, thanks very much, Major Lau. Next, we have comments from Ben Krebs, Public First Law Center. And I would note that in the testimony from the Public First Law Center, which is the new name for, what it used to be, Civil Beat Law Center, now it's the Public First Law Center. In their testimony, they say, efforts are underway to address this matter by way of rulemaking with the involvement of the Attorney General's office. We respectfully ask that this measure be deferred to allow rulemaking efforts to continue. If those efforts fail, we would ask the legislature to revisit this issue next session. Interesting. So we'll find out more about that in questions. Moving on. I'll leave you in suspense because I don't know the answer to that either. Next, Testimony and support from the League of Women Voters of Hawaii. And written testimony and support from other organizations, Grassroot Institute of Hawaii, Hawaii Bulletin, Hawaii Chapter Society of Professional Journalists, and then 3 testimonies from individuals, 2 in support, Lila Maurer and Judge Dan Foley, and 1 in opposition from Andrew Crossland. Is there anyone else here wishing to testify on House Bill 1610? If not, questions, members? Okay, and I'll ask the question because I'm eager to learn more about what we were told in the testimony from Public First Law Center. And so I guess I'll ask the Attorney General. Could you fill us in on what's happening? Because if I remember, if I can take everyone back to the end of session last year, it was House Bill 719 that we took to conference committee, and it was going back and forth, and it didn't come out of conference committee because the Senate had introduced a whole bunch of things on DPP, deliberative process privilege, which was not in the original bill. So I said, nope, we're not going to pass that. And so it ended up not coming out. But apparently in that discussion, there was a lot of negotiations that were going on. Maybe you could fast forward to today, and if you know what's happened with those negotiations and what's this rulemaking that the Public First Law Center is referring to that involves your office?
The AG's office, the Attorney General's office assists the Office of Information Practices with their administrative rules. They do have rules. Cheryl can talk about that more, but they have a set of rules that applies to the fees for records requests. And there were draft rules that were developed with a somewhat different scheme for charges, and those are suspended partially because the legislature seems to have taken an interest in setting fee caps by statute. So I think we were waiting to see what happens with the legislature rather than proceeding with the administrative rules, because we
Okay.
might have to change those anyway.
Okay. Thank you for that explanation. Ms. Park, could I ask you to come up? I see in your testimony, you say in 2017, OIP drafted new rules, solicited public comments on them. Although OIP sought public input in developing the rules, OIP has not yet proceeded to a formal public hearing and rulemaking, as the draft rules remain under review by the Attorney General's office. Additionally, since versions of the measure under consideration have been heard by the legislature every year from 2022 onwards, it would be counterproductive for OIP to proceed with rulemaking when the legislature is evidently interested in setting specific statutory standards for what OIP's rules must say, but has not yet enacted a final version of such standards. So just so everyone knows, that's what is in your testimony. Could you explain a little bit more about where you are in that rulemaking? And if we decide not to move forward with this, will you be able to get into that rulemaking?
Well, yeah, if you are going to stop telling us how we should do it, what amounts should be, put in there, then maybe it would be more prudent for us to move forward on our rulemaking.
Maybe? Maybe it would be more prudent?
It would probably be,
would
I don't know
probably.
where you guys are going to end up.
No,
so-
but if we don't continue to work on this through statute or bills such,
Yeah, then we would continue with our rulemaking process, which at last, back in 2017, we had turned it over for AG review. We have had COVID in the meantime, these bills in the meantime, but if we can start that rulemaking process up again, we'd probably be looking at some more amendments to what we had proposed in 2017. So it's going to take a couple of years before we can finally get it out. Because you have
take a
to
couple of
go,
years for you to do rulemaking?
yeah, because once we go through the process, even before we go through the formal rulemaking process, we seek to involve the public, which is what we did back in 2017. We prepared
Understood.
explanatory material, we had hearings, we got their
understand.
input, and then we, proceeded to make some other changes. Now we're going to do that same thing before we even give it back to the AG for the AG to review, Attorney General's office, for the AG to review, and once they sign off on it, then we can go through the actual formal process of posting it, posting notice in the newspaper and having another formal hearing. So
Okay.
it takes time
Understood.
to do this.
Okay,
Especially
thank you.
something as big as this, because we're going to be revamping it for the first time in a long time. Plus, we haven't even been able to, part of the rulemaking was to also add in fees and costs relating to personal record requests. We don't have rules for, so we would like to continue with our own process and get everything squared away if you give us the green light.
Well, please, I'm giving you the green light, as green as I can make it.
Okay.
And I'm
Send it to me
dismayed
then.
that you're not able to move forward during the time that the legislature's not even in session. But be that as it may, I appreciate your commitment to move forward if the legislature isn't considering a statutory solution
Yeah,
to this issue. Thank you.
yeah.
Okay.
Okay,
Any
thank
other
you.
questions, members? If not, let's move on. Thank you very much to the testifiers. House Bill 1975 relating to the Sunshine Law. This bill establishes accessibility standards for the distribution of public documents and media presentations by boards, as defined in Section 92-2, and it declares that the general fund expenditure ceiling is exceeded with the appropriation that is also included. First up, we have Office of Information Practices.
For this bill, we oppose the placement of this provision in the Sunshine Law and the proposed enforcement of these disability standards by OIP, Office of Information Practices, which administers the state's open meetings law and the Sunshine Law, but we have nothing to do with ADA, Americans with Disabilities Act, or, disability accommodations laws. We don't have that expertise, and it doesn't make sense, I think, for the DCAB, the Disability Compensation and Access Board, to be advising us on this when they should just be enforcing this themselves given their expertise. Or maybe it's the Civil Rights Commission. I don't know, anybody but OIP, because we don't have expertise in this area. And it doesn't make sense for them to tell us how to write our opinions. If they want us to make certain legal determinations based on their advice, then they should be the ones writing the opinions, not us. And ultimately, if you're going to put it with us, then we're going to have to ramp up a whole new section with this kind of disability expertise. And as I would note, there are other people that oppose OIP setting up a whole new standards for disability that might be inconsistent with what federal or state law currently requires. So I don't think that we would be the best agency to be involved in this issue. Thank you.
Thank you very much, Director Park. Next, we have Herbie Shaw, Executive Director of the Disability and Communication Access Board. Please proceed online.
Good afternoon, Chair, Vice Chair, committee members. Kirby Shaw, Executive Director of the Disability and Communication Access Board. And one says we support the intent of the bill. However, and we agree with Ms. Park that as far as this agency is concerned, one, we're not an enforcement agency, so that would really change what we do. We advise, cajole, and inform public and private entities of their obligations under the Americans with Disabilities Act, the ADA, but we don't enforce the law. In addition, it's really, if we're gonna assist OIP in the disposition of complaints. It's a whole different animal for us, and we don't have appropriate or adequate staff to do that. And in short, it's really out of our lane to do that. So anyway, that's our position, really. And thank you.
Thank you very much, Director Shaw. Next, we have testimony of the comments from the University of Hawaii Board of Regents. Testimony and support from James Gashel, National Federation of the Blind of Hawaii. Testimony and support from the Hawaii State Committee of Blind Vendors. Testimony with comments from the Public First Law Center. Testimony and support from Tabitha Mitchell. Please proceed, Ms. Mitchell.
I am trying to get here. Okay, can you hear me?
Yes, we hear you. Please proceed.
Okay, I'm Tabitha Mitchell. I am a resident of Kaneohe, and I am raising a daughter that happens to be blind. She's a senior this year at Kalaheo High School. And what I hear when I hear and read the testimonies and kind of hear a lot of the things that are being said in the room, it's extremely frustrating as a parent of a blind child who likes to go to public meetings and who likes to be engaged in her community. I use an example in Kailua where they had, I don't know, some seahorse, something or other going on with the marsh. And she was going to the meetings on a regular basis and she couldn't ever see any of the maps or the presentations. They didn't have anybody on hand to describe them for her. She couldn't even read the handouts that were being sent out. She asked if she could get stuff in an accessible format and they just simply said, oh, we don't do that. So that's the wrong answer. And when I hear these different agencies talk about how that's not their job, they don't do this or they don't have the capability, we've been doing this accessibility stuff in the school system for 12 years. And now that she's a senior, she's filling out college applications, things are made accessible. That's why we have a lot of the laws that are put in place, but things aren't perfect. So I use her as an example. Every year we train her cohort of teachers in how to make her materials accessible so that it's easy for the teacher and it's easy for the student, the blind student. It's not as heavy of a lift as everybody likes to act like it is. It's simply people reacting because they don't understand it and they don't know what the word means. So we need to do a better job of getting everybody on the same page as to what it means for something to be accessible and what it takes to make things accessible. Just because it's unknown to all of us that are sighted, because trust me, I live in that place. I am a sighted parent. I had to learn, and it's not as hard as everybody likes to make it out to be. And this is a very important process. It's something that needs to be done, and it doesn't need to be continued to pass along. I also don't understand how somebody can say that this is a public forum where you're going to have public information that goes out to people in the general public, but we're not going to worry about the people that happen to be blind that need to read or need to know what's going on. That's just not okay. And I stand on my testimony, and I hope that you guys will listen to the various sides that have opinions with why this is valuable.
Thank you very much. Appreciate your testimony today. Next, we have testimony in opposition from Peter Fritz. Please proceed, Mr. Fritz.
Good afternoon, Chair, Vice Chair. My name is Peter Fritz. I'm a former chair of the Disability and Communication Access Board, as well as the Rehabilitation Advisory Board. I've been an advocate in written laws that include accessibility for individuals with disabilities. I support the intent and I support accessibility, and I've worked with Hawaii Information Exchange and to make changes to the state calendar for it. My concern is that it should be one standard, or this one state, one standard for accessibility requirements. Otherwise, we will have a problem with the definitions that are in this bill that are different than those definitions that currently exist by the ADA and Section 508, which all Title II meaning state and local governments, agencies have to comply with. And this is a concern, to patchwork quilt. The ADA says that a person with a disability is someone who has a physical or mental impairment that substantially limits one or more major life activities. This definition says that the definition in the bill says means an individual having an impairment that limits the individual's ability to obtain information. And then it goes on, including individuals who have no limited vision, no or limited vision, and there's no standard for it. It's limited vision, 2200. There's a whole body of case law right now that exists under Section 508 and the ADA that interprets these particular provisions. Splitting it up into different definitions into different parts of the government can only create complications and difficulties because there is no case law to rely upon. I know what happens when I can't get accessibility. I've filed complaints with the Hawaii Civil Rights Commission. I actually filed one that was preempted by a Supreme Court decision until the Hawaii Civil Rights Commission statute was amended.
If you could summarize, Mr. Fritz, that would be wonderful. Thank you.
Yes, sir. And so people have remedies. They can file with the Hawaii Civil Rights Commission. They can file a complaint in state court. They can file a complaint in federal court, which I've had to do. There are remedies that are available. They're out there. And I think that the state would benefit by adopting a law similar to that attached to the back of my testimony that implies standards that's taken from Florida. It's Exhibit 2 at the very last few pages, which sets forth where the state of Florida adopted these particular provisions in Section 508. So I support accessibility. I know that it can be a problem, but I know that it's been improved with changes the state has made. So I asked the committee to defer this bill until Hawaii establishes standardized requirements for the disability enforcement. Thank you for the opportunity to testify.
Certainly. Thank you very much for testifying, Mr. Fritz. Next, we have testimony and support from Ann Lemke, Emery Mitchell-Butler, Lila Maurer, Clifford Miyashiro, and Brandon Young. Is there anyone else wishing to testify on HB 1975? If not, questions, members? Seeing none, we'll move on. Thank you very much to the testifiers. Next, House Bill 2482, relating to meeting notices, mandates the Office of the Lieutenant Governor or the appropriate county clerk's office to ensure access to paper or electronic copies of all meeting notices and deletes the requirement to post notices in a central location in a public building. First up, we have testimony from the Office of the Lieutenant Governor. Welcome. Please introduce yourself. The floor is yours.
Good afternoon, Chair, Vice Chair, and members of the committee. Michelle Kurihara-Klein on behalf of Lieutenant Governor Sylvia Luke and the Office of the Lieutenant Governor. You have our written testimony, which is in strong support of House Bill 2482. And if I may, I would just like to highlight the second paragraph, which explains our rationale and reasoning for our support. Currently, our office statutory responsibilities require us to receive fax mail or hand-delivered physical copies of boards and commissions meeting notices. We post these documents daily in the chamber of the state capitol for the public to view. However, upon further thinking through this statute, Hawaii is a state of islands with numerous geographical barriers, and it is impractical for those who live on the neighbor islands to fly to Oahu, or even for anyone who lives outside of the immediate premises of the state capitol to drive to the capitol, pass through security, and view these meeting notices. So, because of these reasons, we are seeking these amendments to ensure that our office will provide copy of the meeting notices and agendas. We think that this will be a reasonable resolution to increase efficiency and decrease paper usage of our office. Additionally, I do want to mention, although it's not stated in our written testimony, the location for where meeting notices are currently posted today has been blocked off due to construction for the past 2 months or so. We have posted notices that all agendas are available upstairs at the Office of the Lieutenant Governor on the 5th floor, and if any anyone from the public would like to view these notices, they are welcome to come to our office and we'd be happy to provide them. And it's my understanding that we have not had not one visitor to seek or request these documents in the past 2 months. So again, to speak to the reasoning for why we are seeking and supporting these proposed amendments. I'd be happy to answer any questions that the committee may have. Thank you.
Thank you very much. Next, we have testimony with comments from the Office of Information Practices. Director Park.
We have comments about this bill. 10 years ago, we switched to like electronic posting on the state calendar, and most of the county, and all the counties also now have electronic calendars. So having the LG post paper copies back then was kind of like a transition as we moved from paper to electronic notification. But now it doesn't seem to make much sense to even do that, as the LG's office explained. And, you know, the fact is that if people just want copies of the hearing notices, they would probably be asking the board itself rather than the LG's office to provide them with paper copies. So for that reason, we don't even see the need for the boards to provide notice of their hearings to the LG's office, because they're not doing really anything to get the public, to inform the public about these hearing notices. It's much more effective, and what is being done is posting it on the electronic calendars. So we would suggest just deleting that entire sentence on line 8, on page 1, line 8, that starts with "the board shall file," and it ends on line 17 of page 1.
Thank you very much for your testimony. Next, we have testimony with comments from the University of Hawaii Board of Regents and testimony in support from the Hawaii Chapter Society of Professional Journalists. Is there anyone else wishing to testify on HB 2482? If not, questions, members? Just one question to the Lieutenant Governor's office. Have you had any conversation with the Office of Information Practices? Sounds like they have some suggestions for you.
Yes, Chair, we have had discussions prior to session convening, as well as the Office of Information Practices testified to something similar in a Senate hearing yesterday. So we did have an opportunity to review the OIP's suggested amendments, and we are in support of those changes.
Okay, this measure is your proposal, though.
Yes.
As is, and so that's what you would like to move forward with?
If the committee is...
No, I'm just asking what you would like.
We support OIP's recommended changes, yes.
Okay. Thank you for that information.
You're welcome.
Any other questions, members? If not, let's move on to the next measure. House Bill 1881 relating to administrative fines. This updates the maximum administrative fines allowed for violations of Chapters 84 and 97. First up, we have testimony from Executive Director Robert Harris, Hawaii State Ethics Commission. Welcome, sir. Please proceed.
Aloha, Chair, Vice Chair, members of the committee. Thank you. My name is Robert Harris. Before I begin, I'd just like to very briefly thank this committee and the legislature more broadly for its leadership on ethics. As many of you may know or not know, 10% of all bills passed last year dealt with good government, and it was in large part to the leadership shown in this room, and sincerely appreciate that. Turning to this bill on HB 1881, the Commission is in support of this bill. The Commission did do a national survey of similar entities and found that the national mean is closer between $5,000 to $10,000 as a maximum administrative fee. What this bill does is it's an incremental increase to $5,000. It would still be on the lower end of the scale. Importantly, increasing the maximum fee does not remove the Commission's discretion to issue lower fees for smaller offenses and to consider all circumstances in its decision-making. It also does not change the fees already set in statute, such as fees for untimely filings, which are considerably lower. Thank you for the opportunity to testify. Available if you have any questions.
Thank you very much. Is there anyone else wishing to testify on House Bill 1881? If not, questions, members? Seeing none, let's move on. Thank you very much, Mr. Harris. Next, we have House Bill 2340, making appropriations for claims against the state, its officers, or its employees. This measure makes appropriations, may I say, significant appropriations, and approves payments for claims against the state, its officers, and its employees. First up, we have testimony from the Attorney General. Welcome. Please proceed.
Good afternoon, Chair, Vice Chair, and members of the committee. I'm Skylar Cruz, Deputy Attorney General. This is the appropriations bill for claims against the state, its agencies, and its employees. The bill contains 26 claims. Those claims are described in our written testimony attached as Attachment A. Since the bill was introduced, there have been 2 new claims, and those claims are described in Attachment B to our written testimony. With the new claims, there are a total of 28 claims for a total amount of $13,408,296.37. We ask that this bill be passed with the amendments to add the 2 new claims and to correct the case number of the PAGBA case on page 3, lines 18 and 19 of the bill, as referenced in our written testimony. I'm happy to answer any questions that the committee may have. Thank you.
Thank you very much. Next, we have testimony from Tommy Johnson, Department of Corrections and Rehabilitation.
Good afternoon, Chair, Vice Chair, members of the committee. Melanie Martin, Deputy Director for Administration, testifying on behalf of Director Tommy Johnson. The department stands in support of this measure. Thank you.
And just curious, you're testifying in support because you're
We
included in
appreciate the
here.
legislature's support for funding to pay the settlement of $2 million in that named case, Lynette Reyes versus Eric Tanaka, page 4, lines 8 through 13.
Got it.
Thank you.
Okay, thank you very much. Next, we have testimony and support from the Department of Education and from Dara Yatsushiro. Anyone else wishing to testify on HB 2340? If not, questions, members? See none, we will move on. Thank you very much to the testifiers. House Bill 2349, relating to abolition of joint and several liability for government entities in highway-related civil actions. This amends Section 663-10.5 to abolish joint and several liability for government entities in claims in cases relating to the maintenance and design of highways under Chapter 663 HRS, Hawaii Revised Statutes, so that government entities are only liable in certain cases for the percentage share of the damages they actually caused. First up, we have testimony from the Attorney General.
Good afternoon, Mr. Chair and Mr. Vice Chair and committee members. My name is Robin Kishi. I am a Deputy Attorney General testifying on behalf of the department. As you are aware, the bill seeks to amend Hawaii Revised Statutes, Section 663-10.5, in order to delete language in the statute that was inserted in the year 2006. The original intent of 663-10.5, when it was first enacted, was to limit the tort liability of the governmental entities, whether counties, the city, or the state, to only its proportionate share of fault in each tort case. What happened in 2006 was that the language that was inserted was an exception to this several liability for the tort claims relating to highway maintenance and design. What that did then was it then directs the judges and the other fact finders, whether they're jurors, in the tort cases to Hawaii Revised Statutes 663-10.9, subsection 4. Subsection 4 says that the governmental entities in the highway maintenance and design cases may be subject to joint and several liability if there is reasonable prior notice of a prior occurrence under similar circumstances in those highway maintenance and design cases. What that means is that the judge or other fact finder then has an opportunity to hold the state or county jointly and severally liable with the primarily at fault tortfeasor. For example, and you know,
If you could
sometimes
summarize, that would be great.
what happens is that if there is a prior occurrence that happens under similar circumstances, and the state or the county is only 10% at fault, or 5% at fault, or even 1% at fault, what happens in these cases is that the state or counties may be held jointly and severally liable for the entire amount if the other tortfeasor then has not the capacity to pay. What happens if there is no prior occurrence under similar circumstances is that the reference to subparagraph 3, which is the subsection immediately above, which says then the tort claimant has a second opportunity to hold the state or counties jointly and severally liable if there is no prior occurrence, but the governmental entity is 25% or more at fault. That's how the statute operates, and that is why we are supporting this bill. We would like the law to return to the original statute as it was intended. I'm available to answer any questions.
Thank you very much. Next, we have testimony from Evan Oye, Hawaii Association for Justice. Welcome, please proceed.
Aloha, Chair, Vice Chair, members of the committee. Evan Oye on behalf of the Hawaii Association for Justice. We stand in strong opposition to this measure. Under the current law, as stated by the AG, the state is jointly and severally liable for highway design and maintenance if it's 25% or more, or if it had reasonable notice of the hazardous condition of a similar incident. This measure seeks to abolish the joint and several liability from highway design to reduce government's responsibility to safely maintain our highways. This is a bad public policy because providing highways is a core government function and that the government has exclusive control over, which touches most of our families on a daily basis. The public welfare depends on government's unique role to employ reasonable diligence in design and maintenance of public highways and is at the complete mercy of the government, which retains sole control over the design and maintenance of our highways. When looking at the legislative intent, I think you can cite to Committee Report 8606, in which the committee at that time confirmed that the legislature did abolish a joint and several liability, but not for highway design and maintenance. And this was confirmed when it says the government's unique role in highway maintenance design and the strong public policy providing safe roads for Hawaii's families was contained in there and was to be consistent with the Kleinker decision, which upheld the 25% or more for highway design and safety. So, this is a long-standing public policy, and we, to keep our roads safe for our families, and we just, stand in our opposition to this measure, and we'll be available for any questions. Thank you, Chair.
Thank you very much. That's all the testimony we've received on this measure. Is anyone else wishing to testify on House Bill 2349? If not, questions, members? Real quick, if I could ask the, could I ask the Attorney General to come up, Ms. Kishi? The way I read the committee report back in 2006, which approved this policy, it says specifically that the committee believes this amended measure correctly reflects the original intent of Act 213 prior to the Kleinker decision. To avoid any confusion as to the application of the statute following Kleinker, this measure is given retroactive application to the extent permitted by law. It's very clear that the legislature was fully aware of what they were doing at the time, and they passed this measure to ensure that the state retains joint and several liability over highways. What's different now that we should change this policy?
The 2006 amendment, what it did was it codified the Concord decision.
Yes.
The Concord decision did not anticipate how the statute was going to be used in these 1% cases. What's been happening since the 2006 amendment is that these cases in which there is a one prior occurrence, and there's no definition for what one prior occurrence under similar circumstances means, you can have a plethora of different types of holdings by different judges in different circuits within the state as to what a prior occurrence under similar circumstances means. So there's really no guidance for it. In addition, the one prior accident, there's no context for the one prior accident. So for example, one prior accident on a roadway in which there is an average daily traffic count of, let's say, 1,000, may be a very high accident rate, okay, in that context. On the other hand, one prior occurrence on a roadway in which there's 10,000.
Okay, and I understand that. But what's
different.
different between now and '06 when it was passed? Because they clearly, the legislature at the time was very clear in its intent. Why should we change it now?
Because of the millions of dollars that are being devoted to settlements in this case, because of the risk
So
of
cost
the
is,
exposure.
cost is your driving concern here, the cost to the state.
Cost to the Department of Transportation, cost to the taxpayers, correct?
Understood. Okay.
Especially in those situations where the primary tortfeasor is either unable to pay or can only pay a very minimal amount
Okay.
of what the actual judgment is.
Okay.
So the government becomes an insurer.
Understood. So just a couple of questions. Is the state self-insured, or do we have insurance policies that we can draw on?
The state is self-insured for these types of tort claims up to a certain amount. And it, of course, depends on when the claim is made, when the accident
Okay.
occurs. There is excess insurance for these tort claims above a certain self-insured retention limit. So for example, if it's a 2019 accident, and let's say the self-insured retained limit for the state is $4 million, the state would pay a judgment or a settlement in the amount of $4 million first, and then the excess would then kick in.
Okay, is that the limit, is 4 million? Beyond that, the insurance coverage?
Every year it's different, and what's
Oh.
happening is that the self-insured retained limit is just going higher and higher every year.
Understood.
So in years past, the self-insured retained limit for the state was $2 million. And then after some judgments and settlements, it became 3, then 4.
What is the current limit now, do you know?
I believe it's 5 because in 2019 it was 4. In addition, the excess insurance market has dried up for governmental entities, and not merely for the state of Hawaii, but it's just across the nation.
Okay, and one last question, if I may.
Yes.
You mentioned that it's unclear about this prior occurrence in the, definition of that in the law. Your bill seeks to abolish joint and several liability for government entities in highway-related civil actions. And you're choosing to take that approach as opposed to trying to refine the definition of prior occurrence to make the execution of the law more effective and not left up to the discretion of the judges.
May I explain why?
So, yeah, I'm just curious why you chose to use that approach.
Because under 10.9 subsection 4, what happens is that you're going to have like a range of different types of accidents. Some will involve like the geometrics of the highway, like curves and elevations and downslopes. Other times it may involve a guardrail maybe guardrail placement, or maybe an upgrade to a guardrail. Sometimes it may involve a traffic control device, such
Okay.
as a traffic signal. So it really depends on, and sometimes the prior occurrence may happen on, in a more rural area.
Okay,
And the accidents, the prior accident may be not very proximate in time to the subject accident.
Okay.
In other words, 20 years prior. So you have to give that kind of discretion to the court. What happens, however, is that there really is no guidance for the Department of Transportation. They
is there,
have their
just,
own.
so let me
Yes.
just, rather, I appreciate you're a good attorney, so you're explaining everything. But I wanted to ask, how can we provide the guidance as opposed to just getting rid of it altogether, which is what this bill proposes?
It's difficult to do that in these types of cases because of the range of different types of cases and traffic devices and highway devices that you're dealing with in these types of tort cases.
Okay, so it's difficult.
It really is difficult, and
Okay.
it is case by case.
Okay, well, thank you very much. Any other questions, members? This has been an education for me. Thank you very much.
Thank you.
Okay, let's move on. House Bill 1674 relating to campaign finance. This bill authorizes candidates and their candidate committees to donate residual campaign funds to the general fund of the state or to the real property tax general fund of any county of the state. First up, we have testimony from the Campaign Spending Commission. Mr. Kam, welcome.
Good afternoon, Chair Tarnas, Vice Chair Takayama, and members of the committee. The Commission submitted testimony. We support the intent of this bill, and we are recommending one small change.
See, it's a good idea.
Yeah, well, if that's what candidates want to do, I mean,
Sure, you just want to give the candidates that option.
yeah, well, it's not our bill, but if that's.
I know
what-
it's not. It's our friend's bill.
It really hasn't come up much in our discussions with
Okay.
candidates, but.
Okay, thank you very much. Any other testimony on HB 1674? If not, questions, members? Okay, we're all good. Okay, thanks very much. We'll move on to the next measure. House Bill 1845 relating to partial public financing of elections. I'll summarize just by saying this increases the amount of partial public financing available for all state and county elective offices. And first up, we have testimony from Campaign Spending Commission. Mr. Camp?
Good afternoon again. The amounts that are available under the partial public financing program has not been changed since 1995. The Commission believes that there needs to be some increase. So our proposal is essentially approximately, I should say, a 50% increase for most candidates, except for the OHA candidates, which would be over 1,000%. Currently, a candidate for OHA is entitled to $1,500 for the whole election, and that's really low. And the other notable thing in the bill is that once you hit the minimum qualifying contributions, after that, the state will match $2 for every dollar of qualifying contribution until you hit the maximum amount. Thank you.
Thank you very much. Next, we have testimony in opposition from three individuals, Andrew Crossland, Ralph Hasegawa, and Luann Mahiki Langford Favorito. Their main point is, don't spend government money on candidates. Money could be better used for essential government functions. And then we have testimony and support from Judge Daniel Foley, retired judge. He, as you remember, was the chair of the Commission to Improve Standards of Conduct that produced a lot of bills that we heard last session. Is there anyone else wishing to testify on HB 1845? If not, questions, members? One question I have, Campaign Spending Commission, do you have an estimated appropriation request for this bill?
Well, there's for the two personnel, I think it's at $200,000. Right now, there's 1.9 million.
So the staff position request for appropriations is in the bill, but how about for the rest of the bill?
I don't think, we don't think it's necessary at this time. There's a balance of 1.9 million in the trust fund.
Oh,
In 2022, although it wasn't enhanced under, like it would be under this bill, I think we spent 71,000.
okay. And last question, some people complain about using government money to support campaigns. They don't want to have that happen. Partial public financing of elections is actually in the Constitution, is that correct?
Yes.
And so you've been carrying this out, well, since '78, I guess, when the Constitution was done. But is it? It sounds like it's not a high enrollment of people involved with it. Why is that? Do you think?
Well, I think it's because the amounts that are being offered are too low.
I see. So you're attempting to address that so that you hope to get more people to participate.
Right. I mean, that might be a concern to some people about spending public funds for people running for office, but so is, collecting private monies to, that also has problems too, right?
Some people think so. Okay, any other comments? If not, thank you. Any questions or concerns? Any questions, members? No? Okay, let's move on to the next one. Thank you very much, Mr. Cam. Next, House Bill 1774, relating to missing persons. This measure establishes a Silver Alert program within the Department of Law Enforcement to help locate and safeguard missing persons who are 65 years of age or older, cognitively impaired, or developmentally disabled. It appropriates funds as well. On this measure, we have first up the Department of Law Enforcement. Welcome, sir. Floor is yours. Please proceed.
Good afternoon. Chair Tarnas, Vice Chair Takayama, members of the committee. My name is Michael Vincent. I'm with the Department of Law Enforcement, Deputy Director for Administration. We are in support of this bill. We currently have the MILey, or nationally it's called the Amber Alert, for young children that go missing. We don't have anything in place right now for our kapuna and at-risk adults, and this measure is going to help put a system in place so that we can start looking in a timely manner for these folks that need to be found before something bad happens to them. And the appropriation amount that we are asking for is $250,000. Thank you.
Thank you very much. Next, we have testimony from Kathy Betts of the Department of Human Services, and testimony from Daintree Bartoldes, State Council on Developmental Disabilities, or her representative. Please introduce yourself and proceed.
Yeah. Hi, my name is Savannah Peskin. I'm actually an intern with Daintree, so the Hawaii State Council on Developmental Disabilities.
You have a big job to come here. I appreciate that.
Yeah, I love them. They're awesome.
Oh,
but
that's great.
yeah, so we're in really strong support of HB 1774. We just want to emphasize that the Silver Alert program, it's really important to individuals with developmental disabilities. The Silver Alert promotes safety, security for our individuals with DD, which is developmental disabilities. And we also want to emphasize that individuals with DD are significantly more likely to go missing or wandering, get lost. So it's really important that we establish a system like this, the Silver Alert program, which mirrors the Amber Alert program. Thank you.
Thank you very much. Tell your boss you did a great job.
Oh, thank you.
Next, we have testimony and support from Kamakana Kaimuloa, UPW, United Public Workers. Next, we have testimony and support from AARP, American Association of Retired Persons. Is that right? Did I get it right? Okay. Welcome. Please proceed.
Good afternoon, Chair, members of the committee. First of all, we no longer go by the American Association of Retired Persons. We go strictly by AARP because our members are not all retired, like me. So,
thank you for
so
that
just for clarification. But AARP stands in strong support of this particular measure, as for all the reasons that the officer from the law enforcement had stated. But we also know that, Hawaii enjoys a long life expectancy, so we're very blessed in that area. But sometimes that can come with a double-edged sword. And unfortunately, developing dementia can be one of them. And it doesn't discriminate, right? So we know that. So having a Silver Alert system will really help aid in the search for a loved one who goes missing. I can tell you myself, my own family, we had members who had dementia. My mom, she didn't go missing, but I did have an uncle who went missing for 24 hours, and it was terrifying for the family. Fortunately, we found him safely, and he came home in good shape, but, you know, you can imagine for families who've lost loved ones that goes on for days and days. So having the additional assistance from the public in being aware that this person is missing would really help in their research, or in their search for that and recovery of that individual. So thank you for allowing me to testify in strong support of this measure.
Sure, thank you for testifying today. Next up, we have testimony and support from the Hawaii Primary Care Association. Welcome, sir. Please proceed.
Hi, Eric Abe for the Hawaii Primary Care Association. We are also in very strong support of this measure. You have our testimony. I just wanted to note that our organization has worked very closely with the Alzheimer's Association in formulating this proposal. And just wanted to commend the Alzheimer's Association for their leadership role in getting the word out about this particular issue. Thank you.
Thank you very much. Next, we have testimony in support from the Alzheimer's Association. Well, you got a shout out there.
Yeah, I definitely have to shout out the Hawaii Primary Care Association as well. Vice Chair, thank you for the time. Thank you for hearing this measure. Really appreciate it. We'll stand in strong support as you have our testimony before you. I would also, if you'd allow me, I'd like to send a special shout out to your Vice Chair, Greg Takayama, for really being a champion in the past as well as in the present and sharing his story with regard to this bill and his relation. Very important to us. So thank you very much.
Thank you very much. I share your appreciation for our Vice Chair. Next, we have testimony in support from the Hawaii Disability Rights Center. Lou Erdachek.
Yes.
Please proceed,
Yes,
Mr. Erdachek.
Yes, thank you. Here on Zoom. Thank you, Chair Tarnas and Vice Chair Takayama. We're in strong support, and I just want to tell you a brief anecdote that really opened my eyes to this problem. I mean, as you know, I represent a lot of people with disabilities and their legal issues, but a couple of years ago, I had some friends from Canada who were here from out of town, obviously, for a son's graduation up at UH, and they were staying in the same building where I live in Waikiki. They had fun for a couple of days, and they brought their aunt that had dementia, and then one day she just wandered off. And everybody's like, oh my God, where is Aunt so-and-so? We called the police, they put her on the missing persons list. We actually got her on TV for one of those sort of public service announcements, and we combed Waikiki day and night. We couldn't find her. Then we thought, well, maybe she'll show up at the graduation the next day. She didn't show up. The next day at lunch, you know, everybody's sitting there like, oh my God, where is she? And these people were trying to figure out whether should they go home, should they stay? It was a nightmare. And then finally, she wandered into some beauty salon near Ala Moana and obviously looked peculiar. So the operator called the police. The police came, and so even though they had her on a missing persons list, even with a police report, even though there was a TV spot on it, the police still didn't make that connection. The only way that they returned her to the family is because she had, in her purse, there was a little note saying, if I'm lost, call my niece. So they called her, and fortunately they were able to reunite her. But that really opened up my eyes to the issue, Representative Tarnas, and I saw the video that Representative Takayama shared, and I think at one of the hearings, Caroline from the Executive Office on Aging. It's also been eye-opening to me to realize that I'm not the only one that has had these experiences, but what I think it shows is that we have to do more than we're doing now, and we clearly have to have better coordination, because if the police had her on a missing persons list and then they found her and didn't otherwise make the connection, there's clearly some gap in the current system that we have. And so a silver alert, you know, I'm not the expert on how the alert would be set up, but clearly it seems to me that this would provide better coordination. So I think it's clearly very important, and the price tag doesn't look like it's all that much. So I would certainly urge the legislature to act on that issue this session. So thank you. I appreciate you hearing me out.
Thank you very much, Mr. Erdachek. And we have received 26 testimonies in writing in support from various individuals and organizations. Is there anyone else here or online wishing to testify on HB 1774? Please introduce yourself again.
Yeah, so I'm Audrey Suganakagawa from AARP. It's not in my written testimony, but it just dawned on me about the fact that in this particular bill, it cites the age of 65 and older. I really think we should remove the age because people have dementia of different ages. And then we also have adults with developmental disability who may be younger than 65. And so if we can eliminate the minimum age and just make it an adult, and who have some type of impairments and who are missing, that would be a lot more helpful, and it would expand the number of clients a number of people who could be helped in this particular situation. Thank you.
Thank you very much. Anyone else wishing to testify on this measure? Wait, in the back and then up front. Please introduce yourself and proceed.
Good afternoon, Chair, Vice Chair, members of the committee. My name is Riel Rasmussen. I'm the canine handler for Oahu Search and Rescue. I was involved in the William Burr case at the request of his family, and unfortunately, we were made aware of him being missing 8 days after he wandered away. My canine and I searched Mililani, his hometown, the surrounding areas. We spoke to people who live there or in the park every day, handed out flyers. And despite him being on Crime Stoppers, despite his family going leaps and bounds, way more TV time and notice than most people in this situation would receive, because families don't know what to do. There's no recourse for them currently, aside from reporting them. And unfortunately, most of the people that I spoke to on our searches weren't even aware that someone was missing. They didn't recognize the Crime Stoppers photos that I showed. There's no cause for them to take notice. And in Hawaii, there's so many people that walk down the middle of the street daily that are in various arrays of mental state and dress, and it's just not something that people go, oh, that's odd. There's no reason to go, maybe they need help, because 90% of the time, you approach somebody like that and you're either going to be yelled at or told to go away or asked for money. That's just the reality of it in Hawaii right now. So in my search, it's just highlighted, and I did submit written testimony.
You did. We have your testimony, Ms. Rasmussen.
Thank you. But to highlight just how much a Silver Alert system is going to, that first 4 to 8 hours, that notice and that community awareness is just critical. After that, people forget that they saw somebody on the corner. They forget the guy in the red jacket or the guy that looked confused, the lady that was sitting on the sidewalk. Once that's forgotten, it's gone. And unfortunately, if this had been in place 6 months ago, Mr. Burr's story may have ended very, very differently, because there were people that noticed him and saw him, but the reporting process and the notice process was so far down the line that it was just too late to put the pieces together. So we, both myself and Oahu Search and Rescue, are very much in strong support of this bill.
Thank you very much. Appreciate your testimony. And I appreciate your good work. Yeah. And one more testifier. Angela, please proceed.
Aloha, Chair, Vice Chair, and the Committee of Judiciary. Angela Melody Young, testifying on behalf of Kapolama Neighborhood Security Watch. In strong support, so the purpose of this act is to create a Silver Alert program.
We know the purpose. If you could talk to your specific opinions on the bill.
Okay, so law enforcement policies need to be culturally sensitive and medically sensitive. Okay, so that's why we're in support of the unnecessary broadcasting of disseminating sensitive health and diagnostic information. And when you work with law enforcement, there should be layers of protection of confidentiality provided by statutory provisions through the Hawaii Revised Statute. For example, House Bill 1774.
Focus on this bill only.
Okay, so then basically our support is because this bill is aware of culturally sensitive and medically sensitive things that happen within law enforcement and public safety. So we are in strong support. And about the developmental disabilities, can I talk about that since that was previously mentioned?
You focus on your comments, that'd be great.
Okay, so the reason why medically and culturally sensitive policies are important is because crisis response intervention from the Bureau of Justice, a branch of the Department of Justice, provided a training to train officers with the curriculum crisis response and intervention training for police officers. So they get academic training from
Focus on the Silver Alert program.
the Bureau of Justice for the Honolulu Police Department. It's culturally and medically sensitive, and we're in support of these sorts of policies. Thank you.
Great, thank you very much. I appreciate you staying on topic. You have lots of information. I'm just trying to focus on the topic. Okay, anyone else wishing to testify on this measure? If not, questions, members? Yes, Vice Chair Takayama.
Thank you. A question for law enforcement, if I could.
Yes, sir.
Under this bill, there are a number of conditions that would trigger the issuing of a silver alert. And the third one, I'll just read, says that the law enforcement agency determines that the person has gone missing under unexplained or suspicious circumstances. And I wanted to ask how you interpret that. And before you answer, I just wanted to refer to, as you heard, my own dad suffered from dementia, wandered off. And at the time it happened and we were searching for him, the furthest thing from my mind is what might have happened, you know, I mean, we had no idea. So we don't know if it was suspicious. We do know that all we knew is that he wasn't where he was supposed to be. And so I'm wondering that if a person is elderly and suffering from dementia and isn't where he or she is supposed to be, isn't that adequate? Why do you need to make this determination as to whether it's suspicious or not?
Yeah, just so people know, in the bill it says, specifies that the person has gone missing under unexplained or suspicious circumstances. And is that really necessary?
I think it is, especially if you're going to consider removing the age component.
Let's talk about it separately.
So, I mean, it's two things there. You know, the unexplained, if somebody with dementia, Alzheimer's, one of my employees, for example, had a camera at her father's home. It was always on, and she was always watching him. And if there were times where, hey, I got to leave, go take care of that. It's unexplained. I mean, it's not going to take a whole lot of thought to say if somebody is in this category. Yes, we don't need suspicious circumstances. For some reason, they're not where they're supposed to be. We don't know why they're not there.
Okay, so unexplained would cover a large area.
Yes,
a
lot of flexibility there, a lot of range there.
Thank you. Thank you, Chair.
I want to ask about the age. There's a suggestion from AARP to get rid of the age. What would be the implications of that besides the fact that not everyone who's younger has hair color like mine? Silver alert.
We actually talked about this because in another similar measure, there's no age requirement. And one side of me says you can get rid of it because the other requirements will kick in and take care of that situation. The other, you know, the cognitively impaired or developmentally disabled, that takes care of a big chunk of the population that we're concerned with. So if the committee decided to eliminate, the other factors should be able to kick in and deal with that population that are at risk that we need to go find.
So you're okay if we remove that age?
Yes, sir.
Okay. Okay, any other questions or members? If not, thank you very much, Mr. Vincent, Deputy Director. Let's move on to the next measure. House Bill 1981 relating to traffic violations. This specifies that a portion of the revenues collected from traffic violations shall be dispersed to the county that enforced the violation. On this measure, we have testimony from the County of Kauai, Police Department, the County Council of Kauai, the County of Maui, City and County of Honolulu, Department of Transportation Services, Honolulu City Council, District 7 Board Council Member, the Oahu Metropolitan Planning Organization, and Ulupono Initiative. And just to be clear, Roger Morton from the City and County of Honolulu, Department of Transportation Services testified with comments. everyone else testified in support. Is there anyone here or online wishing to testify on House Bill 1981? If not, questions, members? Okay, let's move on then. Thank you. House Bill 1638, relating to county labor standards. This bill authorizes the counties to require employers to disclose information regarding its employees' wages, benefits, hours, and employment status, and deny, revoke, or suspend a building permit application for violating laws relating to wages, benefits, hours, and employment status under certain conditions. On this measure, we have testimony support from Council Member on Kauai, Council Member on Maui, Michael Formby, Managing Director, City and County of Honolulu, Tyler Dos Santos Tam, Honolulu City Council. Testimony support from another council member on Maui, so that's Council Member Hodgins and Council Member Cook. Also testimony from Council Member Matt Wire, City County, Honolulu. Testimony support from Pacific Resource Partnership.
Aloha, Chair and committee members. Chris Delaney with Pacific Resource Partnership. We represent the Carpenters Union and 250 contractors in the state of Hawaii. We're in strong support of this measure as it allows each county to have the power to adopt labor standards. It doesn't require, but it allows them. It gives them the power to do so. So too often we see contractors coming in, usually out of state. They come in and they commit labor violations to cut costs and to win bids. And they commit these labor violations, and sometimes they get caught by the Department of Labor. They eat the cost of these penalties. They just keep on working, move out, come back in again for a second round to do more work. And we see this continuously happening. And one of the things that this does is it allows the counties to be a part of the compliance team or effort. And this actually gives them the power to stop projects potentially, or as you noted, suspend, revoke permits, et cetera. So it gives them key tools that can help to keep these unscrupulous contractors out of our state and to ensure that the people or the contractors winning the job are law-abiding and they're reputable contractors. Thank you for the opportunity to testify.
Sure, thank you for testifying. And we have testimony with comments from BIA Hawaii, Building Industry Association, Hawaii. And testimony from Nathaniel Kinney, who just walked in the door on Zoom. Nathaniel Kinney, you're up. Please proceed.
Thank you, Chair. I'm away on business, but this is an important measure that we're kind of promoting as just yet another bill to help regulate these unscrupulous contractors. Provided in the testimony, there's S&A Industries who just got fined over $500,000 in back wages by the Federal Department of Labor for jobs that they did on Kauai. And really the only reason why we even knew they were there was because the county alerted us to their presence in the situation when they came down during the pandemic. So much like the general contractors liability bill that we promoted last year and with your help passed, this is yet another tool in our kit to make sure that unscrupulous contractors aren't taking away jobs, because now S&A Industries, after having been fined, is now coming back and wants to do more jobs in Maui and in Kauai. And when we came to the counties, we're like, hey, why are you guys going to give another job or a building permit to this contractor? They're like, well, we're not allowed to. We're preempted from doing anything. And so that's what's brought us back to the legislature saying, hey, can you allow the counties to adopt some of these standards to keep these perennial cheaters from coming back and stealing our jobs?
Thank you, Mr. Kinney. Appreciate your testimony from so far away. Is there anyone else wishing to testify on HB 1638? If not, questions, members? Seeing none, we'll move on. Thank you to all the testifiers. Next, HB 1643 relating to indebtedness. This This measure shortens the time within which a dispersing officer must notify an employee of indebtedness to the government resulting from salary or wage overpayment. This amends the criteria for an actionable cause of action and amends the amount of that a dispersing officer shall deduct to begin immediate recovery of indebtedness based on an employee's gross income. So first up, we have testimony from the Department of Accounting and General Services. Welcome. Please introduce yourself and proceed.
Good afternoon, Chair, Vice Chair, and Committee. My name is Lydia Nash from the Department of Accounting and General Services. I'm the administrator, accounting administrator. I'm submitting this testimony on behalf of Keith Regan, the comptroller. And you have the testimony in front of you.
If you could just summarize the highlights, that'd be great.
Sure. The department appreciates the opportunity to comment, and we support the intent to provide immediate notification to the employee about the salary and wage overpayment upon discovery of indebtedness. And if collection attempts are unsuccessful, the Attorney General may be engaged to further collection if necessary. And the department is also concerned about the elimination of the immediate action in cases where overpayments are equal to or lesser than 1,000, and the establishment of a tiered system based on the employee's gross pay for the amount of the dispersing officer can deduct for immediate recovery. This will significantly increase the resources a department may need to redirect in order to maintain the prolonged amount of time necessary for a department to collect overpayments that are due to the state. And I'll be available for questions.
Thank you very much. Appreciate it. Next, we have testimony in support from United Public Workers.
Aloha, Chair Tarnas, Vice Chair Takayama, members of the committee, Kamakana Kaimaloa, United Public Workers, UPW. You have our written testimony in support. We'd just like to highlight the fact that the current repayment schedule is simply too costly for many of our lower income earners who sometimes bring home as little as $1,000 per pay period. And it's just too much to pay. So minimum payment, $100 or 25% of their compensation. We do support the HD1 that provides for a repayment schedule that would ultimately alleviate some of the financial burden that our members experience. Thank you for the opportunity to testify.
Sure. Thank you very much for your testimony. And we have testimony and support from the Hawaii Government Employees Association. Welcome. Please proceed.
Good afternoon, Chair, Vice Chair, members of the committee. Steve Tevis for Hawaii Government Employees Association. Just following up on United Public Workers, we believe this bill, and we spent some time with Chair Mariyoshi in the previous committee, that this is a bill based on fairness, not one size fits all. Because what it is the current statute is, it would be a deduction no matter what you make. So based on that, we also are in support of the HD1 with the tiered, and we also at HGA has some lower tiered pay rates, and we would say that the tier works in fairness. So again, this is a bill about fairness, not one size fits all. So based on the tiers is on what you would repay at that point. Present for any questions. Thank you, Chair, Vice Chair, members.
Sure. Thank you very much. Is there anyone else wishing to testify on HB 1643? If not, questions, members? Seeing none, we'll move on. Thank you very much to the testifiers. Next bill, House Bill 2199, relating to workforce development. This amends a chapter of the Hawaii Revised Statutes and renames the Hawaii Workforce Development Council to Hawaii Workforce Development Board, and it makes other changes to the organization. First up, we have testimony from Director of the Hawaii Department of Labor and Industrial Relations. Welcome, Director.
Good afternoon, Chair Tarnis, Vice Chair Takayama, and members of the committee. I'm Jade Butay, Director of the Department of Labor and Industrial Relations. We stand on our testimony in support. This measure amends the Workforce Development Council law to be consistent with the state budget and conforms the law to the conflict of interest provisions and the workforce innovation regulations. Thank you for the opportunity to testify.
Thank you very much, Director. And we have testimony with comments from Ken Louie, Chair, and works for Pacific Marine. He's Chair of the Workforce Development Council. And testimony and support from Tuiana Scanlon. Welcome. Please proceed.
Aloha kako, Chair, Vice Chair, members of the committee. My name is Tuiana Scanlon, President of ITSC Local 665 and International Trustee. We standard our written testimony in support and would like to propose amendments which are contained in our written testimony, specifically to reinstate language that was originally in the bill and has been struck. Section 4D pertaining to quorum. I think that's a really important part of the functionality of the board. And Section 6, subsections B, C, and F. Specifically relating to the ability for the council to hold hearings, the ability for the council to negotiate contracts, and the ability to disperse funds and receive funds. These, I think, are very critical and vital elements to the functionality of the board and to make it concurrent with the WIO regulations and requirements. Thank you for the opportunity to testify. Available for questions.
Thank you very much. Could I just ask, did you testify on this measure at the previous committee?
Yes.
Okay. And there's the same testimony?
Yes. Well,
Similar?
Similar, yes.
Okay, great. Thank you very much. Next, we have testimony and support from the Hawaii Workforce Funders Collaborative. And then finally, testimony in opposition from Alan Hayashi. Is there anyone else wishing to testify on House Bill 2199? If not, thank you very much. Any questions, members? Okay, there being no questions, thank you to everybody who testified today. That's the last measure on our hearing for testimony, and the other measure on our agenda is for decision-making only. So let's start decision-making. Go back up to the top of the agenda. Thank you all members for being here. Starting out, House Bill 1610 relating to public records. My recommendation is to defer this measure. I would encourage the Office of Information Practices to move with great speed to promulgate rules so that they don't worry about the House trying to tell them what to do. They just do it themselves as quickly as possible. That's my recommendation. Any questions or concerns, members? If not, thank you. Next measure. House Bill 1975 relating to the Sunshine Law. I recommend we defer this measure because it's got a lot of work that needs to be done, and I would urge the introducer to work with Mr. Fritz and some of the other people who testified to come back with a bill that really addresses all the issues because it needs more work. So my recommendation is to defer House Bill 1975. Questions or concerns, members? Thank you. Next measure, House Bill 2482. I want to honor the initial recommendation from the Lieutenant Governor, even though they changed their mind during testimony and decided they'd support what the Office of Information Practices suggested, which was a significant departure from the bill. And so I would like to move it out as is and encourage the Lieutenant Governor's Office and the OIP to get together and offer testimony that is the same. If Lieutenant Governor really wants to adopt what the OIP suggests, then perhaps Lieutenant Governor should make that as part of her testimony. I think that would be better. So my recommendation is to move this out as is, since that was the original recommendation from the Lieutenant Governor's office. Questions or concerns, members? If not, Vice Chair for the vote on House Bill 2482 as is.
Voting on House Bill 2482, passing as is. Chair and Vice Chair vote aye. Representative Evslin? Aye. Representative Ganadin? Aye. Representative Holt?
Aye.
Representative Ichiyama? Aye. Representative Iligan? Excused. Representative Kong? Aye. Representative Miyake? Aye. Representative Souza? Aye. Chair, your recommendations adopted.
Thank you. Next bill, House Bill 1881. I recommend we move this out as is. It's a State Ethics Commission package. I think it's fine as it is written. Any questions or concerns, members? Not, Vice Chair for the vote.
Voting on House Bill 1881, passing as is, noting the excused absence of Representative Iligan. Anyone voting with reservations or no? Seeing none, your recommendation is adopted.
Thank you. Bless you. Next, we have House Bill 2340, making appropriations for claims against the state, its officers, and its employees. On this measure, I'd like to recommend we amend the bill, pass out a House Draft 1 with technical amendments. I'd like to adopt the recommended amendments from the Attorney General, which includes a correction to one of the claims, as well as the addition to additional claims. I would like to defect the effective date to the year 3000 and move it forward to finance. Questions or concerns, members? No, let's leave it. Yeah, let's leave it. We're going to leave all the numbers in it with the amendments the Attorney General has, so that the Finance Committee knows what the totals are in this measure. Any questions or concerns, members? Nope. No. Vice Chair for the vote.
Voting on House Bill 2340, noting the presence of all members. Anyone voting with reservations or no? Your recommendation is adopted.
Thank you. Next bill, House Bill 2349, relating to abolition of joint and several liability for government entities and highway-related civil actions. I'm reluctant to change what the legislature has long supported and started back in 2006. I think there was valid reasons for that to be adopted at that time, and valid reasons for the state to continue to operate. I know it costs the state a lot of money, but if the state feels like we should tighten up the definition and guidance for how to determine, to provide guidance to the courts, then I'd like to see the governor come forward with something along those lines, rather than just a straight abolition of joint and several liabilities. So I recommend we defer this measure. Questions or concerns, members? Nope. Okay, thanks very much. Next, House Bill 1674, relating to campaign finance. My recommendation is to amend this measure, a House Draft 1. I would like to take the recommendation from the Campaign Spending Commission, which is on page 2, line 1, adding the words, quote, or donated pursuant to subsection E. And with that, I'd like to move it out. Questions or concerns, members? If not, Vice Chair for the vote.
Voting on House Bill 1674 with amendments. Anyone voting with reservations or no? Your recommendation is adopted.
Thank you. Next bill, House Bill 1845. My recommendation is to pass this out with amendments. I'd like to make some technical amendments. I'd like it, in reviewing this, we found that the version of the bill that was online, it was slightly different. There was a section that was missing. It's in the HTML version, but it's not in the PDF version. And it's just one section that it's just a mistake. So I want to correct that by putting the language in there that's supposed to be in there, that is on the HTML version, which people can see. So it's just to correct that so that it's accurate. It already has a blank appropriation amount. And I want to make technical amendments. I want to include in the committee report there is a $1.9 million balance in the trust fund. We'll leave there's a $200,000 appropriation that's in there. I should blank out that appropriation, but put that into the committee report. Note that it's for two positions. I want to defect the effective date to year 3000 and pass that out to finance. I think this is an important measure. Questions or concerns, members? If not, Vice Chair for the vote.
Voting on House Bill 1845 with amendments. Anyone voting with reservations or no? Your recommendation is adopted.
Thank you. Okay, the next measure, House Bill 1774. On this measure, I would like to pass out House Draft 1 with some technical amendments. I also would like to include in here the definition of in the definition section, I'd like to, rather than just citing a section of the Hawaii Revised Statutes, I would actually like to put the language from the Hawaii Revised Statutes into the statute itself. And then, so it's from Hawaii Administrative Rules 11-88.1 to 2, and take the definition from HAR section that I just referenced and put it into the bill itself. And then this is, that would make it clear so that there isn't any confusion. And then I would like to include in here on page 4, lines 3 to 5, delete the section referencing 65 years age. And I would like to include in the committee report the request for $250,000 appropriation. Okay. Anything else? Well, we want to keep unexplained. Okay. Yeah, because I think that took care of it. Do we have to? Doesn't matter. It's either. Yeah. So let's leave it. Okay. Yeah. Sure. Okay, so those are my recommendations. Any questions or concerns, members? Not Vice Chair for the vote.
Voting on House Bill 1774, passing with amendments. Anyone voting with reservations or no? Seeing none, your recommendation is adopted.
Okay, House Bill 1981, relating to traffic violations. It's already got a defective effective date. I'd like to move this forward as is. Questions or concerns, members? If not, Vice Chair for the vote.
Voting on House Bill 1981, passing as is, noting presence of all members. Anyone voting with reservations or no? Seeing none, your recommendation is adopted.
Thank you. Next bill, House Bill 1638, relating to county labor standards. I'd like to recommend we move this out as is. It already has a defective effective date, and it's a good bill. So questions or concerns, members? If not, Vice Chair for the vote.
Voting on House Bill 1638, House Draft 1, passing as is. Anyone voting with reservations or no? Your recommendation is adopted.
Thank you. Next bill, House Bill 1643, relating to indebtedness. I'd like to make the same recommendation, move this out as is. It already has a defective effective date. Questions or concerns, members? If not, Vice Chair for the vote.
Voting on House Bill 1643, House Draft 1, passing as is. Any reservations or no? Your recommendation is adopted.
Thank you. Next bill, House Bill 2199, relating to workforce development. On this measure, I'd like to move out a House Draft 1. It already has a defective effective date. I would just like to make some technical amendments. Any questions or concerns, members? If not, Recon.
House Draft 2? House Draft 1?
It'll be a House Draft 2. Thank you. It's a House Draft 2. Thank you for catching that. So this will be a House Draft 2 with technical amendments only. And just so you know, I heard your recommendation, but because I don't have prior concurrence from the first committee, and they had already heard your testimony and chose not to accept it, I can't really make that change now. So I would urge you to go back and check with the Labor Chair and see if it can incorporate that in a future draft. Okay, House Draft 2, technical amendments. Questions or concerns, members? If not, Vice Chair for the vote.
Voting on House Bill 2199, House Draft 2, passing, anyone voting with reservations or no? Your recommendation is adopted.
Thank you. Okay, now we're going to do just decision-making on House Bill 1766, which we heard on January 30th, oh so long ago. On this one, I'd like to recommend we move it out with a House Draft 1. We will defect the effective date, the year 3000. I'd like to incorporate the Campaign Spending Commission amendments, which is basically to replace the words electioneering communication with the words advertisement, since that's defined. And also make sure that this would only apply to those that depict a candidate and not those that depict a party, since party is not contained in the definitions of either advertisement or electioneering communication. I'd like to make some technical amendments. I'd like to incorporate the amendments from the Motion Picture Association, which is to delete references to artificial intelligence, because you don't need artificial intelligence to produce some of these things. And I would like to codify Section 4, since it will be an ongoing requirement. And then I would like to adopt the recommendations from our member Representative Ganadin, to add a Section C under Section 11, subparagraph C, and the words would be, any person may seek injunctive or other equitable relief to prohibit or cease the publication of a deceptive and fraudulent deep fake against any person who, 1, violates subsection A, or 2, intentionally or knowingly hosts or allows the hosting of a deceptive and fraudulent deep fake in violation of subsection A on the person's website or other online platform. And then also adding subsection E, which says any person may bring an action or for general or special damages against any person who, 1, distributes a deceptive and fraudulent deepfake in violation of subsection A, or 2, intentionally or knowingly hosts or allows the hosting of a deceptive and fraudulent deepfake in violation of subsection A on the person's website or other online platform. Those are my recommendations, so we can pass out a House Draft 1. Defect the effective date to year 3000, if I hadn't already mentioned that. Any questions or concerns, members? Representative Ganadin.
Chair and committee members, thank you so much for continuing this, deferring this till this date. I had an opportunity to check in with lawyers at the Legislative Reference Bureau. For those of you watching, they're the nonpartisan attorneys that work here in the building, and we came back with language that expands standing, which means who can sue for violations of this law. We think that that's pretty important here because this is sort of an evolving thing, so we didn't want to just limit it to candidates who might not have the money to bring these very expensive suits in a variety of courts. Thank you so much.
Thank you very much. Appreciate your hard work on this. Any other comments or concerns? If not, Vice Chair for the vote.
Voting on House Bill 1766 with amendments. Anyone voting with reservations or no? Seeing none, your recommendation is adopted.
Thank you, members. There be no further business before this committee today. We are adjourned.